German statesman Otto von Bismarck once said that laws are like sausages. It's better not to see them being made. Sometimes the law can be very difficult to understand. But Jess, it's time for us to make things a little simpler.
Talking law with Priala Legal, a boutique law firm located in the thriving north end of the Gold Coast, and Despina Priala, the principal of the firm, has practiced property and commercial law for over 25 years, providing top end of town legal expertise where positive client experience is always paramount. And we're proud to say she joins us every Thursday to offer general legal advice on the latest hot topics. So good morning to you, Despina.
Good morning, Jess. Good morning, Wayne. Lovely to be here.
We believe you are up for an award at the moment too. This is very exciting.
You didn't have to mention that, but you are. You have. Well, there's a magazine called the Lawyers Weekly magazine. It's a magazine that's distributed around Australia for lawyers, and every year they have the Women in Law Awards, and there's many categories, and large and small firms enter into these particular awards. Law Firm of the Year or Sole Practitioner of the Year, Boutique Firm of the Year, many different categories. So yes, I've been notified recently I am one of the finalists. Yes, one of the 4 finalists. Yes. Sole Practitioner of the Year, yes.
Very admirable. We hope you win. We think you deserve it.
Oh, thank you very much.
Well, last week, though, we were talking powers of attorney,
yes.
So we thought we might have the flow and effect for companies, because I believe they also have to have estate plans in place, and we didn't get to touch on that.
We didn't, so I thought it'd be a good flow on from last week. So a lot of people don't think about companies when they make their estate plan. So we talked last week about the estate plan encompassing a will and having an enduring power of attorney. That's really, really important. So if you are a director of a company, then the company itself should have a general power of attorney. And a lot of people don't think about that. They assume that I've made an enduring power of attorney, you personally as the individual, and that will cover absolutely everything, including looking after my company if I am a director. But in actual fact, it does not.
So how do you go about assigning someone for the company?
And what happens if you don't have a power of attorney for the company?
True.
So the first thing to say to listeners is, if you are a director of a company, go and have a power of attorney. Make that power of attorney for the company. Get some advice about what the power of attorney, who it should be appointed for the company, because the company is an entity, and the company itself can make a general power of attorney to appoint alternative directors or substitute directors in the event something happens to the directors of that company. It can be limited, it can be for a particular purpose, it can even be put in place immediately. For example, if a director knows that they're going to be away or they're going to be in hospital for an operation, so they're temporarily not available, if they're going overseas on a trip, so that company can then make that general power of attorney. So I have actually got clients who have nominated me, for example, as an attorney for their companies to specifically sign contracts of sale for projects, for example, and that's just a matter of convenience, because if they're not readily available, we have contracts coming in, so they've said, okay, well, we'll put you in to sign on our behalf specifically for that purpose, so it's very limited. And so it's a great mechanism for a lot of different reasons, but particularly what I wanted to focus on today is, if you don't have that company make that general power of attorney, then what happens when the director, the sole director, particularly your sole shareholder, dies or becomes incapacitated?
That's right. And you said it's often a case of trust with a personal one. So in this case, I guess it's so practical to have someone like yourself.
Yes, for that situation. But if the company hasn't done anything, right, and you as an individual has made that enduring power of attorney, and you've said to yourself, I've got my estate plan covered, well, you've left the company sitting over in the corner, not really taken care of, because that's not actually correct. Your attorney can't just become a director, or they're not automatically seen as a director. So that's a mistake that people make. So what has to happen is a few things. So the attorney will have to get some advice, and there is a particular section in the Corporations Act that will or may allow your attorney to get involved in the company, right? So there's a process that they have to go through which is involving making financial decisions, perhaps having shares transferred to that attorney to then become a shareholder, because a shareholder has rights under the Corporations Act to then appoint themselves as a director or appoint someone else as a director for the company. So it's a process. So because it's not automatic, they've got to get advice. They've got to seek that advice and make sure that there's resolutions passed under that particular section of the Corporations Act.
Would you say that there's a lot of companies, perhaps smaller companies especially, who don't have plans like this in place?
Absolutely. There would be potentially many that would not have this estate plan in place, thinking that I've made my enduring power of attorney, I've got an attorney or attorneys appointed, they'll be able to look after the company. That's not necessarily correct. So particularly I'm talking about sole director and shareholder companies. If you've got a company that has a board, or if you've got a company that already has multiple directors, then there may be already a plan in place. And by default, you've already got other directors or appointed for that company. So if something happens to you and you are one director of four, for example, you've got other directors, but it doesn't mean that you should just sit back and just leave it at that, because those directors might not be the right people to leave in charge of the company and the business. So that's also why you should look at getting advice for yourself if you are director of a company as to whether that company should be making a general power of attorney. So if you have co-directors, bring it up in conversation the next time you're having a meeting, informally or formally, doesn't matter. Just say, hey, do we have a general power of attorney for our company? I'm not really sure if we do. Let's have a look at that. Let's talk to a lawyer and see if we should put one in place. So yeah, that's really important to talk about. And if you are a director, a sole director and sole shareholder of a company, and you become incapacitated as well, so we talked about incapacitation, and if you die, particularly if you die, then you've got no one running that. So then again, if you've made a will, your personal representative, your executor, will then have to make steps and inroads to trying to get on board to manage that particular company. And then it gets more complicated if the person doesn't even make a will. So if they've died without a will, there's absolutely no person there as the personal representative in the first place. And then they've got to go off to the Supreme Court and apply for orders, and it's very costly.
Costly and time-consuming, and yeah, you can see all sorts of issues in there. Now, if you have a question about the law, then feel free to pop it into an email and send it to us, breakfast@radio97.com.au, and we'll be happy to ask Crispina that question on your behalf. If you're thinking about building a new home, there are so many things that you need to know. Traps for young players, for example, things like retaining walls. We'll have a look at that next as we talk law here on Radio 97. That's about 8 minutes.